Tonight, Supreme Court strikes out 5 out of the 32 paragraphs of the statement of the third witness for John Dramani Mahama in the ongoing election petition.
We've considered the submissions of both counsel and the testimony and the pleadings in this petition. We have the opinion that paragraphs 4, 5, 6, 7, and 18 ought to be struck out. The rest are maintained.
Lawyers for the petitioner describes the ruling as a great victory for their case.
Out of the 23 paragraphs, in respect of which objection was taken, it was only 5 of them that the court said should be struck out. And for us, that is a great victory.
But lawyers for President Akufo-Addo disagree.
They describe it as a great victory because they realized that Dr. Petsahwai's testimony fell flat, could not stand the test of time. And therefore, they've tried to bring in Rojo to try and re-establish some of those ones.
Tonight, we'll interrogate the issues and bring you some education. And top story is brought to you by Belacqua Mineral Water. If you must drink water, then it must be Belacqua. Gasam Cement, the nation builder, and Vodafone, the future's exciting. Ready? I am Ernest Manu. The Supreme Court has struck out 5 out of 32 paragraphs of the third witness for John Dramani Mahama in the ongoing election petition. Now, Rojo Metal-Nunu was set to be cross-examined today via video link. As we understand, he was unable to attend court due to some reasons, and we'll get into that shortly. But before lead counsel Chachi Chikata could tender his witness statement in, lawyers for the second respondent raised a number of objections, seeking to have 23 out of the 32 paragraphs struck out. Listen to lead counsel Akoto Ampao.
The rules under which petitions are brought do not make provision for reply, as he suggested. But that is the reason why, when you are filing your petition, you must put in all the relevant and material facts, because you know you will not have the opportunity of a reply. Now, my lords, all the paragraphs of the witness statement that we are taking objection to, in our view, relate to material facts, and there ought to have been a pleading of those facts in the petition. Then it will give the opportunity for them to elaborate those facts in their witness statement.
In fairness to the petitioners, you see, most of these depositions, arose out of the evidence of Dr. Petsahwai. But equal examination. But my lord, that actually shows that this witness statement is an attempt to close the problems of Petsahwai's cross-examination. Mr. Silfi, please.
In fact, at the heart of this witness statement,
yes,
is an attempt after the fact to bolster or correct some of the problems with Dr. Petsahwai's thing. But that was not.
No, was there no admission from Petsahwai that he was there with this potential witness?
My lord, what we are saying is...
No. Respond to my question.
Yes. You notice that this witness would have given his evidence but for his sickness. But somehow, as soon as Dr. Petsahwai finished his evidence in chief and was cross-examined, they brought him in. But that's beyond the point anyway. We got well. My lord, my main point is that these are major issues, and they ought, especially when the provisions under which petitions are brought do not make room for reply, they should have
set those key issues. My Lord, indeed, counsel has said in relation to paragraph 15, this is the word he used, these are material facts. That's what he said. When he was making, he forgot himself for that moment. He said, these are material facts. And my lords, again, we refer your lordships to. Have you noticed any of this in the first respondent? My lord, in the first place, he has referred to certain paragraphs in the pleadings as the basis. I'm saying that those paragraphs should have, if they are referable, they should have had the particulars.
And so that is lead counsel for the second respondent, Nana Dankwa Akufo-Addo in this case. Now, counsel for the petitioner, Chachu Chikata, argued why these portions or those portions of the witness statement are necessary and must be maintained. Listen.
My lords, I submit that there is no basis for striking out any of the paragraphs in the witness statement. Prior to her so-called declaration on 9th December 2020, the chairperson of the Electoral Commission did not perform the duty she was supposed to perform in order to be able to declare a winner of the election as she attempted to do. In the entire period after the election on 7th December 2020, she made a couple of very brief visits to...
So, Mr. Chikata, the failure to perform duty you are complaining about, is it the shortness of her visits? Is it the paucity of visits? Is that what you mean?
No, my lords, it is not the paucity of the visits. It is the content of the visits. And the witness statement addresses the content very clearly. The witness statement is very clear about that. And the witness statement...
Their objection is that it's not borne out by the pleadings. It's not borne out from the pleadings.
Paragraph 27 is indicated. In any event, by the time we left the EC premises, the strong room verification process with the chairperson of the EC had not even begun, much less come to an end. All that had happened in the strong room was a series of informal interactions and not the process with the returning officer that is set out in the Constitutional Instrument 127. So that's just a direct response to the question that it is not the brevity of the visits that is the concern of the witness statement.
Mr. Chikata, you see,
Yes.
I have read the petition again and again, and there's nowhere in the petition where this whole story about the strong room had been pleaded.
My Lord, can I? Now, my Lord, if the witness is therefore providing testimony that shows why there has not been compliance with legal requirements, if the witness is providing testimony in respect of that, that cannot be said not to be based on the pleadings.
And so that is the argument of the lead counsel for the petitioner, Chachu Chikata. Court correspondent Joseph Akable joins me in the studio with more on today's proceedings. Joseph, first of all, did the lawyer for the Electoral Commission, the first respondent, argue in this case?
Yes, he spoke twice, and on both occasions he sided with President Akufo-Addo's legal team. He cited a case law to make the point that he believes that if a petition does not make reference to certain facts, those facts should not be allowed in the witness statement. And so that was his contribution. And on the second point, when he came in, he reminded the court that it is as a result of allowing the petitioners to file a witness statement post cross-examinations taking place that has put the court in a current situation that it finds itself in a situation where you have witness statements coming in that address issues that have already been raised earlier. Very
well. Now, after that, the justices, after the argument, they took a recess, came back with their ruling. Let's listen to the Chief Justice, Kwesi Ninyeboa, read out the ruling of the court with regards to the application for portions of the witness statement to be struck out.
The second respondent counsel has raised objections to various paragraphs from the testimony of Robert Joseph Manu, PW3, in these proceedings. The relevant paragraphs, the subject of the objection, are from line 3 of paragraph 4, paragraphs 5, 6, 7, 8, 11, 16, 17, 19, 20, 22, 23, 24, 29, 30, and 31. Are objected to on the ground that they are not supported by the pleadings. Paragraph 9, 15, and 18 were objected to on the basis that they raise issues as to authenticity of documents in the election that the court has already dealt with. Paragraph 10 was objected to on the ground that the petitioner is seeking to build a new case. Paragraph 12, 25, and 26 are objected to as reflecting the opinion and irrelevant to the issues in controversy. Petitioner's counsel has argued that the objections are not supported in law because the testimony is premised on either the petition and the pleadings and the answers and prior testimony of the second witnesses, Dr. Pasa White, on the 3rd of February 2021, and the answer of the first respondent herein. We've considered the submissions of both counsel and the testimony and the pleadings in this petition. We are of the opinion that paragraphs 4, 5, 6, 7, and 18 ought to be struck out, and as they have no foundation in the pleadings or supported by the evidence, and the same is hereby struck out. Yes, the rest, that is the remaining paragraphs in the witness statement, are maintained. So in fact, apart from paragraphs 4, 5, 6, 7, and 18, the rest of the paragraphs remain.
You're here live on Top Story on Joy 99.7 FM. We've been joined on the phone line by a member of the legal team for the petitioner, Ejudi Tamaklo. Thank you very much, Mr. Tamaklo, for your time here on Top Story. Now, Dominic Ayene, one of your team members and indeed your senior, did speak to the media today and describe the ruling as a great victory for your case. But if you look at some of the areas that were struck out today, I believe that for those who have been following, it goes to the heart of your case. Now, Joseph Akablaze with me in the studio. We just want to read certain portions of the paragraphs that were struck out by the court today, and then we'll take your reaction to that, Joseph.
And so, point 6, which was struck out, it says dedicated fax machines, printers and computers were provided for the strong room that were to receive faxes from fax machines at the Regional Collation Center in full view of agents of candidates and then projected on an overhead projector in the strong room as the results were received. EC officials manned the fax machines on 9 December for many hours. The fax machines in the strong room were not working. One could see the frustration on the face of many of the dedicated fax machine EC personnel. It goes on to say that instead of that pre-arranged transmission system for the regional collation seats to be transmitted, what happened part of the time was that one of the deputy director of the EC, Dr. Siribo Kweku, would from time to time bring into the strong room what was claimed to be a regional collation seat. How he got those sheets was not disclosed.
And so, Mr. Tamaklo, if you listen to this, and as far as we understand your case, the transmission, collation, and declaration of the result goes to the case you're making, the petition you have in court today. If such a paragraph has been struck out, how then do you explain that it is great victory? Help us.
I think that the use of the great victory must be taken in a certain context. By the way, good evening to your listeners. Now, what is clear is that having filed this witness statement, 33 paragraph witness statement, the second respondent's lawyer raised an objection to 23 of it. Now, of the 23, the court agreed with them relative to 5. So it is within the context of the number of paragraphs that the objections were taken in relation to that my learned senior used the word great victory. Because if out of 23, only 5 were sustained, that's significant relative to the 23.
Very well.
And that is why he said it's a great victory.
But if you consider the substance of this paragraph, for instance, doesn't it go to affect your case in any way?
It is something that we can still maintain. As far as we were concerned, we came with our witness statement. An objection was taken. The second respondent wanted to rip off the entire witness statement. If a witness statement of 33, and you are taking 23 out, what will be left? And usually for a witness statement, the first 3 paragraphs are usually just to talk about general matters. So if you take 23 out of 33, that was going to be, basically throwing the entire witness statement out. It's important to make the point that the entire witness statement of Rojo Meto goes to the very credibility of the chairperson of the Electoral Commission. And if the Electoral Commission, the chairperson's credibility is gone, it directly affects the beneficiary of her declaration. And that is why you notice the spirited objection from my learned senior, Akoto Ampao, relative to the testimony of Mr. Rojo Meto. Significantly, the video recording of his own witness, Peter McMahon, whereupon he had an interview with Paula Domotri, that testimony on the video, that's the interaction between Mr. Peter McMahon and Paula Domotri, is significant. It is going to form part of the record. And by the time that video is played for all of us to watch, it will be clear that there is no basis for the chairperson of the Electoral Commission to deny their own interaction with the agents of the NDC and the petitioner in the course of the declaration of the election results and its collation. Yes, so it's true. Paragraph 5, 6, 7, 8, and 18 have been taken away. But the ones left can still make our case.
But if that video, for instance, was so crucial to your case, and like we've heard the counsel for the second respondent making calls very vociferously, why did you not plead it or mention that in your petition?
So you see, okay, so it's important, and thankfully, 2 of the judges were my civil procedure lecturer, the CJ himself and my Lord Justice Mafusao. They both taught me civil procedure. Now, ordinarily, in the normal course of pleadings, you have your statement of claim. Then you have a defense. Now, when the defense comes, you have the opportunity to file a reply. However, the election petition that we have is obviously sui generis. Now, however, when you pick the election petition and the CI deny, among others, there's no opportunity for a reply. Now, when you file your petition, you can never anticipate what the nature of the answer will be. For you to even anticipate in your petition a possible reply to an answer that has not come yet. However, anybody who has done trial will note that when you are leading your witness to give his evidence in chief, what you usually do in wrapping up is to say that in paragraph so and so of the answer or statement of defense, the defendant say this. What do you have to say to it? So the person gets the opportunity to respond. And so, evidence in chief is also an opportunity for you to respond to the statement of defense, hear the answer to the petition. And so, the whole business that everything ought to have been pleaded. Like Marlene Senior, Mr. Chikata said, you do not, with respect, plead evidence.
Very well. And Mr. Chikata, on the issue of the opportunity to respond, I want to bring in Nana Adjoa Adobia Asante, who is with the legal team of the second respondent, because Roger Metal Nunu's witness statement comes in at a time when they have filed their document. I want to find out from you, Nana Adjoa, does this hurt your case in any way? Seeing that those on the other side are coming in after the time given by the justices.
So good evening, and good evening to your listeners. As was stated rightly by the counsel for the first respondent, it is because the court has been quite magnanimous with the petitioner that we see that after cross-examination of these two witnesses, there has been the opportunity to call a third witness. It's foreign. It's quite foreign to our practice. But it's something that we would accept the direction of the court. And what we keep on asking ourselves, and I'm sure a lot of people ask, is what is the relevance of Roger Metal-Nunu's statement? What is its relevance to the determination of the 5 issues that have been set down for trial?
If it were not relevant, I'm wondering why you wanted 23 out of the 32 struck out. And especially when some of the portions of it, I heard your lead counsel make the point in court today that some of those issues had been determined when Dr. Pesa White, mounted the witness box, and they had made the justices had already pronounced on some of those issues and thought that it was not fair that counsel for the petitioner had raised them again in Roger Metal Nunu's witness statement. But then the court upheld some of those areas.
Exactly so. We had to go through the basic rudiment of challenging certain portions of the witness statement, which we believed should not have been part of the witness statement. Buttressing the point, cross-examination exposed certain holes in the petitioner's case, which we feel is unfair that they had the opportunity to now fill those gaps. However, we are happy that the court upheld some of some of the paragraphs that we objected to were struck out by the court. With those that have been maintained, we look forward to cross-examining the witness on it. Because as I have said, we do not see the relevance of this witness. And we keep on asking ourselves, what is the relevance of this witness to the determination of the 5 issues that have been set down for trial? What is the relevance of these supposed errands that he went on and supposedly being instructed by the EC to go on? How does that determine who had obtained more than 50% of the total valid votes cast? How does that have a bearing on whether there was compliance with Article 63.3 of the 1992 Constitution? It has no relevance to the issue set down for determination. So we are poised to cross-examine the witness on Monday, and we are sure we will further expose the reason why the petitioner's petition does not disclose any reasonable cause of action.
You essentially wanted the court to throw out the witness statement because 23 out of 32 it's almost gone. But then the courts decided to uphold quite a good number of them, and your friends on the other side described that within this contest as victory. For those who follow the case today and are convinced and look at how the judges now uphold some of the arguments which were earlier struck out at the time of Professor White when his witness statements came up, and say that perhaps you're losing your case, how do you respond?
That is not true at all. As I said, as we all know, the law is in the bosom of the judges. We accept the ruling of the court. We do not think the witness in itself is relevant. We went through the basic rudiments of pointing out the reasons why we thought that the paragraphs were not born out of the pleadings, or they were irrelevant, or they were statements of opinion. The court arrived at a decision. We are okay with the decision. And as we have continuously said, indeed, the presence or neither the presence nor the absence of Roger Metal-Nunu or the other agent, that is Dr. Pesa White, had any bearing on the performance of the constitutional duty of the first respondent. So it does not affect it in any way.
Nana Joadobi Asante, I want to thank you for your time. Mr. Tamaklo is still with us on the line. Mr. Tamaklo, what should we expect on Monday? Mr. Roger Metal-Nunu will be cross-examined, but can we expect another witness? Because you had indicated 5 from the beginning. Now we have the third person. Should we expect another one?
Like the last time Mr. Chikata said, until we get to the bridge, asking how we're going to cross becomes a bit more. What I do know is that the court adjourned proceedings to Monday, 9:30 a.m. to enable the cross-examination of Mr. Roger Metal-Nunu. I'm very confident about that happening. If that happens, remember that even in our petition, we had indicated that we're going to call 5 witnesses.
Exactly.
I have no indication of further witnesses being called. Once that is done, we should be closing our case for the witness of the first respondent to take the box.
Mr. Tamaklo, I want to thank you for your time. That's Ediji Tamaklo. He is a team member of the petitioner's legal team and, of course, a team member of the NDC's legal team as well. That's it for Top Story, brought to you by Belacqua Mineral Water, Gassam Cement, the Nation Builder, and Vodafone. The future's exciting. Ready? Ghana Connect with Benjamin Akato is up next. After this break, please stay with us.